Okay, so I think we'll start. We might have a few other people trickle in, but thank you for joining us. This is a panel on marine protection, and I'm sure it will be wonderful. We have two great speakers today. First, speaking will be Sue Fisher, who earned her law degree and qualified as an attorney in the UK. Since 1994, she's worked at animal protection and wildlife conservation NGOs in the UK and in the United States, mainly in policy advocacy roles. Her primary focus is the conservation of whales and the regulation of whaling by the International Whaling Commission, which she'll be discussing today, as well as the regulation of trade in endangered species by the Convention on International Trade in Endangered Species of Wild Fauna and Flora, CITES. She is a board member of the Species Survival Network, a coalition of over 80 conservation animal protection organizations worldwide that work on wildlife trade and trafficking issues. Sue is currently a consultant on marine issues for the Animal Welfare Institute. She has 2 young boys and lives here. And Jenny James will be giving the second presentation. She graduated from the University of Chicago Law School, where she served as a co-chair of SALDEP. Jenny's path to law school began in California, on the beaches, where she spent nearly a decade rescuing stranded seals, sea lions, and otters as a volunteer with the Marine Mammal Center. Funding from her school's public interest fellowship program allowed her to join ALDF as a litigation fellow in 2012. Her fellowship focused on marine mammal protection issues, among many other issues, and one of her earliest projects involved drafting the petition that convinced the National Marine Fisheries Service, to add Lolita, the orca held at the Miami Seaquarium, to the endangered species list. When her fellowship ended, Jenny became counsel to PETA, where she works now. She works as part of the PETA Foundation's Captive Animal Law Enforcement Division, and has recently also headed PETA's newly formed Legal Innovations team, which generates strategic impact litigation. So, without further ado.
Thank you. So yes, I'm going to be speaking about whaling today, but as befits such a large animal, it's a big topic, and I've struggled, considering my audience, really how to pitch this for you. That most of you are attorneys, but you're attorneys who want to make a difference in the world. So obviously I'm not going to be giving you a law lecture. What I want to do is to give you some perspective on where we are today with the whaling issue, with commercial whaling, and to try and put that into a historical context, a political and economic context. Because I think as you go forth in the world, practicing law on behalf of animals, as I've come to realise over the years, much of what you achieve is dictated by the politics, the political context in which you're operating, and the whaling is certainly an issue where that's absolutely true. So where we are today, as most of you probably know, is that we have a long-term worldwide ban on commercial whaling, but we have 3 nations, Norway, Iceland and Japan, who are still hunting whales for commercial purposes, and doing that it was in some considerable numbers. And they're doing that, sadly, with impunity. They're doing that legally. So what I want to explain is how we got to where we are with the International Whaling Commission and how we are today with those number of whales being killed. To do that, though, I need to give you a brief history lesson, and I really am truncating millennia of whaling into a couple of minutes here. So clearly, consumption of cetaceans, that's the collective term for dolphins, porpoises and whales, predates written history. Certainly indigenous people have been hunting whales for thousands of years in the Arctic. And in the rest of the world, presumably some person found a stranded whale on the shore, decided to see what it tasted like, and decided to try their hand at finding a fresher one at sea. So that's, we assume, how whaling began. And whaling as an organised practice was originally for meat. By the 10th and 11th centuries, the Basque people of northern Spain had organised themselves, organised their whaling, originally hunting for the right whale in the Bay of Biscay, and they called it the right whale because when they shot it, unlike most other species, it didn't sink, it floated, so it was the right whale to catch. But as the precedent that we see throughout the history of whaling started here. They took all the right whales from the Bay of Biscay, and once they'd exploited their resource, they'd moved offshore. They took their taste for whale meat, their practices, their whaling practices, through Northern Europe, through Ireland, Iceland, Norway, and ultimately to the east coast of North America through Newfoundland and Labrador, and all the way showing their practices to other cultures who adopted them, like the Yankee whalers adopted those practices in North America. By that time, by the 10th and 11th centuries, they were still eating the whales, but they weren't hunting them at that point for their meat predominantly. They discovered, again, some bright spark rendered down a whale to see what they got, and they found something astonishing. The oil of a whale, rendered from its blubber, has quite unique properties. At that point in history, the oil was used, the wax from it's solid at room temperature, so the wax from the oil was used to light candles, and that drove the Basque people. It fueled their culture, and that's what we saw as whaling evolved. So again, I'm really compressing history. In the 1600s to 1800s, as industries and economies and cultures developed, whaling, along with them, became more mechanized. It evolved into national fleets, which became competitive with each other. We saw the advent of steam vessels, which could then hunt the bigger species of whales. The larger ones could obviously move much faster. And we began to see those national fleets moving themselves, not just from home bases, but establishing remote bases far away at sea, where the whales would be rendered and the oil in barrels stored to be traded all over the world. But it wasn't until the 1900s that whaling became truly industrial as we know it today, with the advent of factory ships, massive vessels that could spend months at sea, taking hundreds of whales at a time and rendering them down on board or collecting the oil from the remote stations. And that was what we know of the we all know that whale populations were decimated, and it was the factory ship whaling of the 1900s that has caused that. So it doesn't hurt to highlight it. Almost 3 million whales killed in the 1900s. 870,000 sperm whales. It was an astonishing number. It was the largest removal of biomass the planet has ever seen, the removal of the whales. 60 to 80% of them were taken in Antarctica, because in the southern hemisphere at least, whales, once they've bred in the tropics, will migrate in massive numbers down to Antarctica, where the krill and the plankton are blooming, to feed in astonishing numbers in the Antarctic summer. And it became like hunting fish in a barrel. These remote whaling bases and these national fleets competing with each other would spend their austral summer down in Antarctica taking as many whales as they could. As a result, some populations were reduced by as much as 90%. The blue whale as a species was reduced by more than 98%, and some entire populations were lost. So I said they were hunting for oil, but why? What for? Well, as I said, whale oil supported entire economies. It allowed whole nations and cultures to develop and industrialize. So as I said at the beginning, used to make candle wax, but then it lit the lights and it greased the wheels of the Industrial Revolution in the 1800s. By the early 20th century, glycerin from whale oil was used to make the glycerin-based explosives that won the First and the Second World Wars. Between the wars, it was used to produce margarine, which my mum remembers eating in London between the wars, and soap on a massive scale, not just for personal use, but for industrial purposes too. And then, as I said, it has remarkable properties, and the oil of the sperm whale in particular has incredible properties, not from the blubber, not rendered from the blubber, but from a cavity in its head. Sperm whales hold this substance called spermaceti, which has odd properties. It's an incredibly emollient substance, so it was used, as many people know, in cosmetics, in lipsticks and other cosmetics, but also as a lubricant in fine motor parts like the watch you see there in cameras. And then it also has a very low freezing point, so it was used by NASA, maybe by other countries, in space exploration, because it was a good commodity to use in space. So all those products have petrochemical or plant-based alternatives today, but what we need to remember is how as I said, they fueled the development of entire economies and entire countries. But there was no regulation. All there was competition and increasing efficiency in killing the animals. And as I've said, we saw the decimation of entire populations and species. So clearly what was needed was international regulation, and several attempts were made in the 1930s to bring the major players of the day together: the US, the UK, the Soviet Union, Japan. But those attempts each failed for various reasons, but mainly because there was no incentive at that time to protect the whale in its own right. The incentive was to protect the industry, to protect national interests, protect territorial interests. And consequently, either one of the major players would fail to show up to the negotiations or would refuse to implement what was agreed, if anything was agreed, and often it wasn't. And if it was too weak to be meaningful anyway. And the decimation continued. Ultimately, it took, right after the Second World War, in November 1945, the US was in the position, as the only nation in the position really at that point, to step up and call those major 10 or 15 whaling nations together to Washington, D.C. And remarkable that it happened so close after the end of the Second World War. And they managed to agree the International Convention for the Regulation of Whaling, which established the International Whaling Commission, the body through which parties would agree on restrictions and quotas. And again, I think looking at the political context, we have to remember that date, 70 years ago, when we lived in such a different time in terms of international governance and wildlife conservation. And it's actually remarkable that the ICRW doesn't just give itself a mandate to regulate whaling. It also, uniquely for its time, has in its objects and purpose the conservation of whales. Unfortunately, though, given the politics of the day, with nations just coming out of a world war, inherently mistrustful of each other, the way the treaty was written, the insertion of this conservation and this management mandate into the treaty basically inserted a fundamental contradiction in the treaty itself, and it's been left to future generations. And I can tell you a whole lot of lawyers over the years to try and determine what the founders ever really intended. So here it is, being signed. And as I said, it was really the earliest recognition of the need to protect a wildlife resource for its own sake, and objects and purpose, including both those mandates. So what kind of treaty was it? And again, given the politics of the day, it had to be a certain kind. There are two kinds, as most of you know. Treaties where decisions are taken by consensus, like CBD in the Climate Change Convention, where all the parties have to agree on everything, which of course takes time and it takes compromises. And the outcome, if there is one, and often there isn't, is the lowest common denominator. And then there's the kind like CITES and the Montreal Protocol and many fisheries agreements that takes its major decisions by majority rule. In most cases, a 2/3 or a 3/4 majority is needed for big decisions like protection or removal of protection for the resource. And in this situation, whether you vote for the measure or not, if that majority is achieved, you're bound by it, which of course is only really true in theory. IWC, because of the nature of the politics, had to be a majority rule treaty, and it established a 3/4 majority needed to adopt quotas, to open or close seasons, so whaling wouldn't be allowed during breeding season, for example, to protect particular populations, or to open and close specific areas, and they're known as sanctuaries within the IWC. So what would be the incentive, given that as a country seeking access to a resource, you could be outvoted by your competitors if they ganged up against you? What would be the incentive to join or to comply with this kind of treaty? So, as is fairly typical with a majority rule treaty, the founders inserted into it an objection provision. And again, this is fairly common in fisheries agreements, and it provides that a party that doesn't want to be bound by a specific provision, as long as it lodges its objection within so many days, exempts itself from the effect of that decision. And that's what they included in the ICRW. What they also did was to insert Article 8, the infamous scientific whaling loophole. And again, the permission to take a resource, to kill whatever it is, the fish or to fish, typically, for research, isn't uncommon in fisheries agreements. But what the founders of the ICRW did was to apply that, notwithstanding anything else in the treaty, so including any other restriction like a zero quota, that right, because it says that they shall be permitted, the nationals who are granted permission to take whales shall, as far as practicable, process them, and which, of course, once the science is done, you have massive quantities of byproduct, valuable whale meat, and then they're allowed to deal with those byproducts as they see fit. So essentially, the founders introduced into the treaty the right to take whales for this scientific research provision, irrespective of any other restrictions that were imposed. So given that countries could ignore restrictions by hunting under objection, or they could take whales through the scientific whaling loophole, how was whaling regulated? Well, it wasn't, and how was it monitored? It barely was until the 1970s when the IWC finally introduced an observation and inspection scheme. But even then it was too weak to be helpful, and by then the damage had been done. So for example, just after the Second World War, and over the next 30 years, the Soviet Union took 90,000 more whales than it reported, an astonishing number of whales. And catch data was falsified by other countries too. Norway and Japan covered up catches of undersized whales, so young whales that shouldn't have been hunted, protected species, and then hunted in closed areas and during closed seasons, and failed to report. So how could that be dealt with? If a country was found to be doing something like that, what could be done? Well, unfortunately nothing, because the ITRW has no compliance mechanism, no enforcement provisions, nothing to ensure that if an infraction is committed that there can be some consequences. It doesn't even helpfully define what infractions are. It's left up to the contracting government to determine that an infraction has been committed and then address it domestically. It also, unfortunately, has no compulsory dispute resolution mechanism, which means if two countries have a fundamental disagreement, there's no mechanism within the treaty to try and resolve that difference. And if there are differences of agreement over how to interpret the treaty, again, there's no mechanism to resolve that. So we have a situation, to give you an example, where New Zealand believes that the ICRW doesn't just have a mandate to conserve and regulate big whales, it also has a mandate to conserve small cetaceans, so the small whales, dolphins and porpoises, which are hunted in much larger numbers than the big whales. Japan fundamentally disagrees with that, takes the opposite position. And those mutually exclusive positions just can't be resolved. The Commission cannot, unless there were a three-quarters majority achievable, which is impossible politically, can't resolve those fundamental differences. So what we've had in political terms is the pro-whaling and the anti-whaling nations really entrenching their positions over what they believe the competence of the treaty to be, disagreeing over whether welfare is an area of competence for the Commission, disagreeing over whether these small cetaceans can be regulated. And those divisions have got incredibly divisive, to the point where they've disrupted annual meetings on a regular basis. Which in practice, we have another problem, that the Secretariat, unlike the CITES Secretariat or the CMS Secretariat, has no access to independent legal advice. So when we have a disagreement like over the rules of procedure, there's no independent arbiter about who's right. So to give you an example, we had, a few years ago, Iceland decided to walk out of an annual meeting, stomped out in a huff, took about 15 countries with them. And we spent the next 2 days of the annual meeting, the NGOs sitting outside because we couldn't do anything, and commissioners and their legal advisors locked in a room somewhere privately, trying to interpret what the rules of quorum were in the rules of procedure. And there was no independent arbiter able to determine that for them. So the meeting just shut down. So given that, I think it's almost amazing that there were only whales left, because through the 1960s, when we had 60,000 whales a year dying, and through the 1970s, although the Commission did manage to ban whaling on some populations, it seldom managed to get that three-quarters majority to do it before the hunt was commercially unviable anyway, and the hunters had moved on to the next most viable species. And maybe, as you know, the blue whales were the first to go because they had the biggest yields. Once they were commercially unviable to hunt, the nations just moved down to the next smallest species, to the point where really only the minke whale, which is the smallest of the big baleen whales, was viable by the 1980s. But we had the Save the Whale movement, and that absolutely changed the perspective of the Commission. Again, politics helped to drive the law. And what they managed in 1982, after a few attempts at a worldwide ban, a worldwide ban on commercial whaling was achieved. But it was, again, the product of politics. They had to be negotiated to an extent with the whaling nations, even though they were outvoted in the ultimate vote. So it wasn't a permanent ban, it was an open-ended pause, whilst the scientific committee undertook an assessment of the status of the existing populations. But if you look at what it did, it's remarkable. I mean, it did bring that purple peak down to almost nothing in 1986 when it came into effect. So 7 out of the 10 remaining whaling nations gave up at that point. But it wasn't the end, because of the nature of the International Whaling Commission and the politics. It was a compromise, and it was also forced on those whaling nations. And as I've explained, they have multiple ways around it. And maybe I wouldn't go into too many details here just to save time, but this is the situation we're in today. So Japan has 2 research programs. The famous one, the infamous one in Antarctica, which is also an IWC sanctuary, but Japan lodged an objection to that when it was agreed in 1994. It's taking 4 species. There are 2 different species of minke whale, and sei and Brutus whales, setting itself quotas for the 2 hunts of about 600 a year. But that's actually, I won't be able to get into this now, but perhaps in the question and answer session I can. Australia took Japan to the International Court of Justice a couple of years ago, claiming that its scientific research whaling was invalid. And the court determined that, yes, Japan's research was not, its program was not for the purposes of research. And again, we hope maybe it was the end, but as is the nature of this issue, it's never the end. And Japan took a break for a year, and it's actually now rewritten its research proposal, its research program, and it will resume its hunt this year in Antarctica, but at a level of 300 whales a year rather than 800 odd, and only the minke whale now. Norway took an objection to the moratorium as it was decided back in 1982, and it's conducting commercial whaling under that objection still today. It sets itself a high quota, but typically takes around half. It took 660 this summer. The lower number because there is so little demand ultimately for whale meat these days, and I'll come back to that. Iceland left the IWC. It's good at leaving in a huff, Iceland. Left the IWC after the moratorium was agreed, and then came back in 2002 with a reservation, which is essentially an objection, but one that you can take, although this was, again, a great topic for lawyers to discuss. Took a reservation to the moratorium. It dabbled in scientific whaling for a couple of years, but then started commercial whaling under its reservation in 2006, and takes an astonishing number of fin whales, the 2nd largest whale on the planet, and an endangered species. Sets a quota of over 150 of those a year, and a large number of minke whales, but takes many fewer minkes than it sets a quota for. And interestingly, this is a slight digression, Iceland is a magnificent destination for whale watching, and many thousands of people from all over the world go to Iceland each year to watch whales. Unfortunately, way too many of them get off the whale watching boat and wonder what whales taste like, and go into restaurants in Reykjavik. And these 29 minke whales taken a year are feeding tourists. Icelanders have almost no interest in whale meat. The hunting of minke whales is predominantly driven by curious tourists. So keep that in mind if you ever go. So, where are we now? Given the dysfunction, as it's been described of the IWC, or the stasis that we have with the balance that's tried to be reached between conservation and management, and the impossibility of the parties deciding which they want the IWC to prioritise, what is the future? Well, the important point to make is that demand, as I said, for meat is falling. And Norway, Iceland and Japan all subsidise their hunts. Norway has to subsidise even the marketing of whale meat to keep people eating it. But I don't think it's about meat anymore. I think we've almost gone full circle to when those first people realised what those astonishing properties of whale oil were. And all three of the whaling nations and other countries besides are acutely aware of this. So Norway is already spending quite a lot of money examining the pharmaceutical potential of certain compounds in whale oil, running clinical trials to see if it's an effective medicine for certain medical conditions. They're finding what we call nutraceutical uses, so food supplements. Whale oil contains omega-3, and it's a ready source of omega-3 for food supplements in Norway. It's even examining, there's a recent study we found that Norway is looking into the medical properties of whale blood plasma, looking at whether that can be used for any useful medical uses. All three countries are very aware that whale oil has potential to feed farmed fish and farmed animals as well. Its fat to protein ratio apparently is perfect for feeding farmed fish and farm animals. And fuel too. So Iceland, for the last couple of years, has been using the oil to fuel its whaling vessels, claiming that it makes it much more environmentally friendly to hunt whales when you're recycling them into your engines. But there you go. And all three of them are able, because they took reservations to the ban on international trade in whale products that was agreed around the same time as the whaling moratorium by a different convention, by CITES. Because of their reservations, they are able to trade whale products with each other. And Iceland is now importing winky whale meat from Norway, the previous tourists, presumably. So, given where we are, this creaky 70-year-old treaty that has all these inherent contradictions and problems, what's the future of whales? Well, I don't think whaling is the biggest threat to whales anymore. I hate what's happening. I'm concerned about this movement towards hunting whales for oil rather than meat. But the reality is whales are threatened by a lot more than just whaling these days. And I think this is the future of the International Whaling Commission. So as we see, whales are threatened by climate change. We have no idea what loss of sea ice is going to do at both poles to their sources of food. We're seeing ocean acidification affecting their food stocks. We're affecting their food stocks. We're overfishing fish, as everybody knows. UVB radiation is affecting the plankton that they need to feed on down in Antarctica. Bycatch, we don't just take their food, we catch them in our nets, and some 300,000 cetaceans a year are caught in fishing nets. Now that's not just the big whales, that's mainly the small cetaceans, the dolphin and porpoises, but that's a frightening number. They're compromised by marine debris. They're ingesting these microplastics that we're all hearing about. They're ingesting other trash that we're dumping in the oceans. They're getting entangled in ghost nets that fishermen just let go. And they're being hit by vessels. So whales that are migrating along shipping routes, like the still critically endangered right whales, the few hundred right whales that are left on the east coast, are incredibly threatened by vessel traffic out of those east coast ports. And of course, we're disturbing their environment. They live through sound, and we're pumping frightening levels of sound into their ocean, just through vessels, through seismic testing, and so on. And then also chemical pollution. So the toothed whales, the dolphins and porpoises, feed right at the top of the food chain. So any contaminants that their prey is consuming is biomagnified at every level, to the point that dolphins and porpoises now have such high levels of contaminants, organic compounds and heavy metals in their tissues, that we're seeing health effects in human consumers and awful health effects in the children of pregnant consumers of whale products. And clearly these are having dreadful compromising effects on the whales and dolphins themselves. So I don't know how much more time I have, but okay. I think the IWC has a future. Its reputation isn't good. Its history, its past history, is not impressive. But we have what we have, and we need to deal with it and work with it. And it's finally, I think, being able to make some progress on these issues. So Japan doesn't like the fact that we're exercising a conservation mandate, but its allies, it's allowing these things to happen. So in the last few years, we've seen some, I think, exciting programs. For example, when we look at Bycatch, the entanglement issue, the IWC is now it's established a training program for somebody who works within the Secretariat to train people all over the world to disentangle whales caught in fishing gear. You don't want to try that on your own. These animals are enormous and it's potentially very dangerous. So these people are providing training programs for people everywhere to safely disentangle the whales. We hope there might soon be an equivalent program to help whales which have stranded, either to refloat them if they're viable or to euthanize them humanely if they're not. It's beginning to grapple with the issue of vessel strikes, so trying to determine where whales are most at risk, why they're particularly at risk from certain vessels, and try and mitigate those threats. And it's gradually being able to look at welfare issues. That's been one of the hot button third rail issues within the Commission that the pro-whaling nations just do not want the Commission to touch. And it's very hard to make progress on welfare issues relating to hunting. But I think we are seeing progress being made on welfare issues that come as a consequence of these threats. So I don't think it's all doom and gloom. I think we have to look at the Whaling Commission, as I've tried to show, in a political context, in an economic context. It's not all about the law. The law is complicated and difficult, a little flaky in the ICRW, but certainly as I've found since I practiced corporate law as it was years ago, I've made more progress in my life working as an advocate than I ever probably would have done as a corporate lawyer. And you can't operate in a bubble. The law is always about the politics. So I'm hoping I've given some kind of context for where we are on one particular legal issue. Thanks.
So Sue's done a great job covering the international angle of things, so now I can indulge myself and tell you a little bit about what we do domestically here. And the bulk of what we do for marine mammals is done under the Marine Mammal Protection Act, which has been doing a pretty good job protecting most marine mammals since 1972. 1972 is the year that my very dear friend William Rivas Rivas was born. And it was the year after I was born, which means it was shortly before my mother decided that it was perfectly acceptable to dress two very different looking sisters as if they were twins, which was actually sometimes cute. And the Marine Mammal Protection Act was drafted before Nixon fell from grace, but it was passed after Watergate. And it exists because Congress cared about dolphins like these, who at the time were routinely dying in nets of tuna fishermen. And this practice had really started 20 years prior when tuna fishermen capitalized on this curious relationship that tuna and dolphin have. Yellowfin tuna swim underneath pods of dolphins. So the dolphins make it easy to find the tuna, and then modernization of nets made it easy to just catch the whole lot of them. And so they would keep the entire school of tuna and toss away the dolphins as bycatch. And since those 1950s, more than 6 million dolphins have died that way, which, as you told us, commercial whalers only killed half as many of those in the entire 20th century. So it's a big problem. So Congress, through the Marine Mammal Protection Act, put a moratorium on the take of marine mammals, which means that unless you've got a permit, you cannot lawfully harass, hunt, kill, or capture a marine mammal on land or at sea, and it's illegal to possess a marine mammal or marine mammal parts that have been taken in violation of the Act. But as usual, permits can be issued for certain things, including scientific research, enhancing the survival of the species, for educational or commercial photography, and public display, my favorite, And polar bear parts can also be imported if the bears were killed in Canadian sport hunts, so that sucks. But thanks to the Marine Mammal Protection Act, fisheries are now regulated, and so they're allowed incidental catches, or incidental takes, but they have to follow best practices, and there is a goal of zero mortality. And, as it turns out, regulation worked. We haven't reached zero mortality, but reported deaths are down 99%. And the Marine Mammal Protection Act really didn't do this all by itself. The Marine Mammal Protection Act has a tendency to get by with a little help from its friends. And in this case, the friend was the Dolphin Protection Consumer Information Act, which Congress passed in 1990 and created the now ubiquitous Dolphin Safe label that you guys would see on tuna, except for I know none of you eat tuna. Since then, the U.S. has vigorously had to defend this label with challenges before the World Trade Organization. Mexico's been fighting and arguing that the labeling regime is discriminatory because tuna collected in the Pacific is held to a higher standard than tuna fisheries in other oceans. And that whole saga is way more complicated than we have time to get into, so here's the short version. To use the Dolphin Safe label, if you're in the Eastern Tropical Pacific, you need both your captain and an independent observer to certify that no dolphins were harmed when you collected that tuna. And that's because they're still using that method of finding the dolphins and then collecting the tuna. It's just now they have to let the dolphins go. And so this is still extremely stressful, probably still results in mortality later. But as long as everybody can say, hey, the dolphins got out of the nets, they can sell that tuna to you as it is dolphin safe. But if you're not in the Eastern Tropical Pacific, all you need is the captain to certify it. And so I get why, Mexico's a little mad about that, but whatever. And the good news is the WTO agreed that the U.S. can favorably prefer this dolphin-friendly fishing method, even though what's in the can is indistinguishable. And so that was kind of a big deal because animal welfare could matter. And really, it should have just been is the product different? And then you could treat it differently. So, yay. But the bad news is the U.S. is still doing it wrong. And just this past April, the WTO actually sided with Mexico and found that the Dolphin Safe label requirements still discriminate against them. I'm pretty sure the U.S. will appeal and it will continue. And actually, I don't even know how much the U.S. cares about the WTO, so we'll see what happens. But in the meanwhile, we do still have bycatch problems. They've come up with a new trend, which is this. This is they're called fads, and it's a fish aggregating device. It's just another way to lure schools of fish to come all the way together. And again, there's a ton you could say about bycatch, but here the issue isn't so much marine mammals, but the size of the fish. And here smaller tuna are being collected prematurely, so they haven't finished their whole reproductive lives, and so they're really ruining their own industry. And then of course they're catching other types of fish and turtles and, so bycatch, yay. And then as Sue mentioned, marine mammals still have bycatch issues. This is what it looks like when you find a ghost net. And they're just floating all around the ocean indiscriminately. And then whales, usually their problem is crab pots or lobster pots and kind of lines that run vertically, and they end up getting wrapped around various parts. It's actually, if I were a whale, I'd probably choose to have it around my fluke like that, but you can also kind of get it stuck in your mouth, or you can end up with just more than just the rope. You can really get weighted down if you're a whale. And for these guys, the Marine Mammal Protection Act doesn't do very much for them. It's at most just another incidental take. But thankfully, nonprofits pick up where the Marine Mammal Protection Act lets off, and some of them remove that deadly ocean debris. Others of them will track down and disentangle the whales when they can. And the disentanglements are coordinated and authorized by the National Marine Fisheries Service, or NIMS. So NIMS is part of NOAA, which is the National Oceanic Atmospheric Administration, and both of those are under the Department of Commerce, which means they got a little more money. And NIMS is obviously in charge of fisheries and also has jurisdiction over seals and sea lions and cetaceans, which are dolphins and whales. And NIMS is required under the Marine Mammal Protection Act to track the births, deaths, and transfers of any captive marine mammals while they're in captivity. Now, the U.S. Fish and Wildlife Service, they also have responsibilities under the Marine Mammal Protection Act. They're under the Department of Interior, so they have a little less money. And they have jurisdiction over sea otters, manatees, walruses, and polar bears. And I don't know why, but they don't have to keep an inventory of those animals when they are in captivity. And then over both of these agencies is the Marine Mammal Commission, which was created by the Marine Mammal Protection Act. And those guys, they're all about the policy and the science. They do review some permit applications, some take permit applications, but mostly they advise the Secretary of State on kind of marine mammal conservation issues. They're pretty badass. So you might think that 3 agencies would be enough. You know, got some marine mammals, you got 3 agencies going on. And I would think that you would be right, except for in the 80s and 90s, Congress amended the Marine Mammal Protection Act, handing over a bunch of power to a 4th agency, perhaps my least favorite agency in the world, the United States Department of Agriculture. And in the 1988 amendments, those weren't so bad. The most relevant change for our purposes was the additional condition placed on applicants who wanted to take marine mammals for public display. And Congress said, hey, you know, you guys got to offer a program for education or conservation purposes, and that program needs to be based on professionally recognized standards, and it also has to be acceptable to the Secretary. Then they also said the facilities had to be open and could charge an admission fee. But yeah, they were probably already doing that. But then 5 years later, the public display community hadn't really articulated what these standards would be. They probably didn't really necessarily have a great interest in doing so. So NIMS said, oh, that's all right, we got it covered. We'll come up with some of those standards. Now, they had the gall to suggest that these programs should convey accurate and current information, and that information should be consistent with the policies of the Marine Mammal Protection Act. I know, pretty crazy stuff. They also wanted these places to discuss the animal's life history, their behaviors, and their role in the ecosystem. So, yeah, they didn't stop there. NIMS also wanted to provide a comprehensive regulatory foundation for all this marine mammal stuff they were doing, and they wanted to require permits in place of different kinds of less formal authorizations they had been doing for transactions involving these captive marine mammals. And they wanted to address this interesting confusion that existed, which is whether captive-born progeny of pre-act animals, so marine mammals who were taken before 1972, were actually covered by the act at all. And so they felt very strongly that they were, because kind of logically it seems like they would. So they were going to resolve this confusion by defining take to also include holding a marine mammal captive. Like, how awesome would it have been if that had happened? Every marine mammal who was captured or captive-born after 1972 would have then been held pursuant to a permit. And then finally, NIMS also planned to impose captive maintenance requirements, including addressing social groupings in a much better way than had been going on at the time. And then they were going to regulate swim with the dolphin programs, which were popping up all over the place. So the industry lobbied really hard against these changes, and they won. Congress, under the guise of streamlining the Marine Mammal Protection Act, totally gutted it, at least as applied to captive marine mammals. For starters, Congress defined harassment in ways that really only applied to animals in the wild, so kind of making it clear, like, no, we don't think it's a take, because if it's not even harassment, it's certainly not a take. And then Congress also watered down the requirement that display facilities have to have educational programs. Suddenly and really subtly, these programs no longer had to be acceptable to the Secretary. The Secretary could only just determine whether the programs were in fact based on these professionally recognized standards of the public display community. So now educational is whatever the industry says it is. And recall that, you know, back in the 80s, they couldn't even say what it was. So, and then Congress also added a requirement that facilities had to hold an Animal Welfare Act license or permit, and that's fine, and they probably already did, but what it effectively did was hand that power over to the USDA over these captive marine mammals, and NIMS felt like their jurisdiction was stripped and have functioned kind of that way ever since. And so yeah, the Animal Welfare Act always applied, but it was kind of secondary then, and now it's really, really primary because they threw it into my Marine Mammal Protection Act. But wait, there's more. Congress also made sure that once a permit was issued to a display of marine mammal, that no additional permit would ever be required to take, import, export, purchase, sell, transfer, or transport that animal. So those amendments basically insulated the captive display industry, which protected them from what really should have been the Free Willy effect. But 20 years later, we do finally feel the Blackfish effect. Which brings us to last week's sensational California Coastal Commission hearing, which I'm guessing many of you followed that showdown, and I know some of you were actually there and got to speak, and I'm totally jealous. SeaWorld San Diego was seeking a coastal development permit to proceed with its Blue World expansion, which was going to enlarge SeaWorld's orca tanks and really enlarge their orca breeding program. And the commission, through California's Coastal Act, they controlled the development of all of California's coastal zone, and they're tasked with protecting, among other things, all marine resources in that zone. So the hearing was a very, very long day, but I cannot even imagine how many hours various organizations put in the days and weeks before the hearing. And I know firsthand that PETA and ALDF certainly made this project a priority, and AWI for sure. I mean, it's the Naomi Rose show. So everybody was really working on it. I know that PETA and ALDF had organized presentations at the hearing, and they both sent advocates to lobby all the commissioners in advance. So PETA, of course, sought a full denial. You know, just don't let them expand. But ALDF got to offer this attractive middle ground, approval, but with conditions. But despite all of this groundwork, the commission staff report still recommended just go ahead, grant the permit, no big deal, no strings attached. So things were actually looking pretty grim that day. It was not supposed to be an exciting day. But after weeks of lobbying and hours of testimony and public comment, the commission actually granted the permit, but only on the condition that the park end its captive breeding program. And the commission also imposed a ban on transferring orcas into or out of the park, with the one exception that any orcas who were held under a Marine Mammal Protection Act permit were, it had to be consistent with federal law, and since, as I mentioned before, that permit means that SeaWorld can take, import, export, purchase, sell, transfer, or transport those animals without any other further review. SeaWorld could still do that if they choose to do that. But the bummer for SeaWorld is that very few of the 11 orcas held at its San Diego park are actually held under a Marine Mammal Protection Act permit, because most have been born after. And really, this is because SeaWorld lobbied so hard in the 90s to make sure that NIMS would be stripped of their jurisdiction and that permits wouldn't apply to captive marine mammals. So I think they're a little sad about that now. It's a really delicious irony because, the Marine Mammal Protection Act is federal law, so it could preempt the state California Coastal Act. And in fact, SeaWorld pretends that it still does and argued that preemption exists, but there's a presumption against preemption. So you have to have a reason, and preemption really can generally only exist if there's an express preemption, or if there's a conflict, you can't follow both laws at once, or if the federal law occupies the field. Well, Congress went out of its way to kind of make it clear that the Marine Mammal Protection Act only protects marine mammals in the wild, so that's the field that it's occupying. So sure, the Marine Mammal Protection Act very clearly prevents states from prohibiting or permitting anybody to take a marine mammal from the wild, but it has little to nothing to do to say over the treatment of captive marine mammals. So SeaWorld also argued that the Animal Welfare Act preempted the Commission's interest in captive marine mammals, and that was my favorite because I'm like, did you guys read it? Because sure, the Animal Welfare Act definitely does have a lot to do with captive animals, but it has an express provision that does not just allow states to exercise concurrent jurisdiction over captive animals, it invites them to. The Animal Welfare Act knows that it sucks and that it hasn't been updated. It's like, if you guys want to do better, please, by all means. And so one state, South Carolina, has even done this. They went so far as to ban marine mammal captivity altogether, which was totally awesome, but their ban was never tested in court, and then they rolled it back, so now they have captive sea lions. But whatever, the law is still on the books. But it looks like SeaWorld will be the first to take the issue to court. They've announced their intention to sue the commission. And so I'm really interested to see if they're going to cling to their really hollow preemption arguments, or if they're just going to go with their other claim, which was that the Coastal Commission exceeded its jurisdiction when it considered the care of captive marine mammals. But here's the thing about the Coastal Act. It specifically invites the commission to become involved to the fullest extent possible in all federal matters that affect the coastal zone. And although the Coastal Act focuses on protecting open spaces and wildlife in their natural state, it contains no limiting language that excludes captive wildlife. And rather, the legislature just required the Commission to protect all marine resources that exist within the coastal zone, as SeaWorld's orcas plainly do. And the Coastal Act also applies to both natural and artificial resources, and whether they're in public or private hands. So to find that the Act protects only open spaces and free-roaming animals would really render a lot of this language meaningless. And the Commission also has exercised its jurisdiction over every part of the coast, from pristine preserves, but also to abandoned, decaying industrial areas and landfills. And so just as the Commission still controls natural spaces that have been spoiled, it should retain jurisdiction over orcas, whether they've been captured or captive born. So stay tuned there. And another recent victory that I suspect you're all familiar with was Georgia Aquarium's failed bid to secure a permit to import 18 wild-caught belugas, which they desperately need to prop up their dying captive breeding program. And when I say they, I mean the entire public display industry, because Georgia Aquarium does not have room for all 18 belugas. They were going to share with the Chicago Shed Aquarium and with all 3 SeaWorld parks. Now, the last time a permit has been granted to import a wild-caught cetacean was in 1992, and that was actually for belugas, but those were caught from Canadian waters. And so it was 20 years before the industry tried again. It's not that NMFS has been like, nah, you can't import them. It's just politically it was unpopular to do. And so NMFS ended up denying the permit application in August 2013. And mostly this was because the aquarium couldn't show that the removal of these belugas from the wild was not detrimental to the Russian stock from which they were taken. And the stock just hasn't been studied enough. We don't know how many. Russia's got crazy authorization to take numbers and numbers of belugas out. And then the even more interesting thing was that 5 of the belugas were taken when they were so young that they were probably still dependent calves and they were nursing, which directly violates the Marine Mammal Protection Act. And so the aquarium sued NMFS, and they did so under the Administrative Procedures Act, which allows people to challenge a final agency action that's arbitrary and capricious or otherwise in violation of law, that sort of thing. It's kind of the catch-all, and it's an animal lawyer's bread and butter. And so, but the thing is, courts almost always show agencies a ton of deference in these acts. They don't want to do a lot of second guessing. So what was so exciting about this one is this time agency deference was on the side of the animals. And I was like, rad. So I'm not at all surprised that NMFS won, which they did. And I was just glad that it was finally not the other way around. But the victory is totally still bittersweet because the ruling just keeps the belugas out of the United States. It does not grant them their freedom. And America does. It has a tendency to export its bad habits in the same way that, we exported our bloodlust for commercial whaling. We're exporting our love of keeping marine mammals for display. And so, but at least now we're not contributing to the demand for more removal of animals from those Russian waters. And the public outcry was also so good that SeaWorld announced they weren't going to take any of these 18 orcas, even if Georgia Aquarium could win. So poor Georgia Aquarium had to hold the bag, and I almost feel sorry for them. Another victory that you guys might have known of was, and this one's was when the NRDC and a whole bunch of other people, including ALDF, sued the NMFS and the Navy because NMFS had authorized the incidental take of literally millions of marine mammals over a period of, I think, 5 years. These marine mammals could have been anything from just disturbed to deafened or straight up killed, and also if you deafen a marine mammal, you basically killed him anyway. And this was all just so the Navy could, do their war games with their deadly sonar training exercises. Now here again, agency deference was working against the animals. So, but here the agency review was so bad that the court still sided with us. There have been a bunch of sonar cases. This was just over what was going on offside Hawaii and Southern California. And the Marine Mammal Protection Act is just one of the laws in play in these cases. Really, NEPA, which is the National Environmental Policy Act, does the heavy lifting. It was also passed into law in the early 70s, and it requires the government to perform extensive review of any actions that might harm the environment. It's really one of the heavyweights, right up there with the Endangered Species Act. Like, they're pretty cool. So once the Navy knew it was losing this most recent sonar suit, it agreed to modify its training plans in order to settle the case. And so now they're doing what they should have just done in the first place, which was agreeing to temporal and geographic restrictions on their war games. So they're going to avoid harming marine mammals when they're particularly vulnerable or in particularly sensitive areas. So, and then even though you often see the Marine Mammal Protection Act and NEPA working together, sometimes they don't see eye to eye. And the saga of the Bonneville Dam, which is here in Oregon, is one of those times. The lethal control of sea lions at the Bonneville Dam is actually one of the reasons I decided to come to law school. I wanted to understand how, in a world where there's a Marine Mammal Protection Act, that states could be allowed to kill sea lions for eating salmon. And it was actually in 2008 when NIMS first authorized Oregon, Washington, and Idaho to kill sea lions for eating salmon at the Bonneville Dam. Now, granted, these are endangered salmon, and the sea lions are just protected. And when I say sea lion here, I mean like that normal kind of run-of-the-mill Pier 39 sea lion. The sea lion has a much larger cousin, the Steller sea lion. Stellers are listed under the Endangered Species Act, so in a showdown between a Steller sea lion and an endangered salmon, it's kind of a much more fair fight. But the thing is, Stellers do also hang out at the Bonneville Dam, so it's just complicated and messy. So yeah, I really thought the Marine Mammal Protection Act must be doing something to protect marine mammals who are just doing their thing. They're eating fish like they're supposed to. And before the 1994 amendments, this might have been true. But at the same time that Congress was caving to the public display industry, they were being lobbied hard by the salmon fishery. And so in 1994, they added an express provision to the Marine Mammal Protection Act to allow NIMS to authorize marine mammal takes whenever marine mammals pose a significant threat to endangered salmon. So, but here's the thing. Sea lions at the dam eat at most 4% of the salmon that come through the dam. Fishermen, all kind of combined, take something like 17%, and the dam kills another 17%. And yet, NIMS didn't stop the fishing. They didn't order the dam to be removed. They just found that predation by sea lions was having this significant threat on the salmon. And they authorized the removal of sea lions who could be identified as repeat offenders. And that's why in this picture you see that sea lion is branded, because it's not enough that sea lions could be killed. They had to be branded first so that you could identify which ones were guilty of actually eating the salmon. And this is a hot iron brand. They put them in a squeeze cage, and they just do it right next to the dam where tourists could see. And it sears into their flesh, and then you see them in the water with their bloody wounds. It's terrible. So you can see probably my confusion and why I was like, yeah, marine mammals, yes, protection, not so much. So it was the Humane Society of the United States that took up this fight, and they sued again using the Administrative Procedures Act. And at first they won because, court was like, the numbers don't add up here, dude. 4%, 17%, what's going on? But when you win an APA suit, often all the agency really has to do is look at their numbers a little bit better and give a better explanation. And so that's what they did. And the Ninth Circuit has now blessed this explanation. NIMS has to judge the impact of fishermen and the dam under NEPA standards. But NIMS has to judge the impact of sea lion predation under the Marine Mammal Protection Act's standards. But the Marine Mammal Protection Act's significant threat standard is a much lower bar than the one under NEPA, so sea lions get the boot. And there's one final case that was the other real mystery for me and another reason that I went to law school. And that's Casa Beach, which is in La Jolla, California. And I was just like, how do all these jerks get to routinely harass this harbor seal rookery? And it wasn't just that people were harassing these shy harbor seals without punishment, I get that. It's that the city was actively trying to remove the seals from the beach. And at the time I was, volunteering with the Marine Mammal Center, I couldn't even rescue on a rookery without getting permission from 5 different people. And yet you go to La Jolla and the city is trying to get them off the beach. So what really happened was the city said they had to because they were granted the beach under a grant that said the pool was supposed to be used as a children's swimming area. And this was, early 1900s or whatever. But it's a really cute, quiet cove. And so the harbor seals kind of took it up as like a great place to play around and have their babies. And so because the water doesn't move a lot, the water's kind of full of poop and fouled. And so the city felt obligated to remove them. But remember preemption. You're like Marine Mammal Protection Act. That's federal, and it should trump this state land grant. But you'd be wrong. And that's because the Marine Mammal Protection Act actually lets municipalities and other folks remove marine mammals who pose a threat to public safety. And the crazy thing is it's not even a take, it's just allowed. And so that's why preemption didn't work. We tried to argue it, and actually the attorney who argued it is Brian Pease, and he's here, and I'm sad he's not in this room, but I read his case for some of the SeaWorld stuff. So he tried preemption, and it was a really good try, but it did not apply. So instead, after many, many years of litigation, the issue has been resolved by legislation. The state changed the conditions on the land grant, and they said the beach could also be used by marine mammals. And then they also ordered the beach closed during pupping season, because if you want to use it when they're not having their babies, that's fine. But if you use it when they're about to have their babies, they're going to have premature births, there's going to be maternal separation, and it's just a bad thing. But then if you're closing a beach, you're closing off coastal access. So they also had to get the blessing of the California Coastal Commission. But the California Coastal Commission, as we all saw, they're pretty badass, and they said sure. But when I was reading up to do this, you would think like, okay, it's over, yay. But I read that the people who still hate the harbor seals, and I mean, seriously, who hates harbor seals? But they are either currently suing or they are planning to sue the Coastal Commission. So poor Coastal Commission, but they're doing good, so stay tuned there. Now, the Marine Mammal Protection Act turns 43 on October 21st, which for you Back to the Future fans is Back to the Future Day. We have seen a lot of change, and some of it's been for the better. We traded Nixon for Obama, and I'm all grown up. But Congress, well, they're distinctly less helpful now. But in light of those 1994 amendment shenanigans, I think it's probably a good thing that they're a bit dysfunctional. So that's what I've got for you.
Thank you, Jenny and Sue. That was great. And we have about 10 minutes for questions. Yeah?
Thank you both. That was so fantastic. I learned a lot. This is more for Jenny, but Sue might be able to weigh in. So this kind of goes along with what you were just discussing about how the MMPA doesn't really get to apply to a lot of things as much as we hope. So some states, such as California, have like potential non-lethal deterrence methods that fishermen or women can use. And so this is like firecrackers, circling boats, using noisemakers, and things, or paintballs. And so I'm wondering, is it the same issues that it's just not rising to the level of harassment under MMPA, or is it preemption, or yeah? So I wonder like why they're allowed to do that to sea lions and seals and not actually have a harassment issue.
Yeah, I actually almost put that in the talk too, because I was another chief mystery, and it's interesting. I didn't even realize that that's something under the state law, because the Marine Mammal Protection Act regulations also let you do that.
Oh.
And the firecrackers are the most insane because, kind of they're a noise deterrent, but really sea lions are a lot like dogs, and they catch those in their mouths sometimes. And I have rescued more than one sea lion with no jaw, necrotic tongue. And so yeah, that was why I was like, I'm going to law school. This is stupid. And so you're allowed to use it because in theory, it's not a lethal, if you used it correctly, it would not be a lethal deterrent. And fisheries are regulated. They're okay. And so I think it's a problem of under enforcement. You just don't know who threw that one. And then they're just going to say, oh, I didn't know they always catch them like dogs. Well, I know, so you probably know. And actually, if we want to blame anyone, I think that is the salmon fisheries too, because it happened about salmon fishery time. So if you're really going to have to eat some sort of fish, please, for the love of God, don't eat salmon or tuna.
Thank you.
Do we have other questions?
elaborate more why you hate USDA, and also why you don't hate FDA more than USDA?
I probably just have not had enough experience with the FDA. And had we had more time, if I had the talk all to myself, I would have gotten into the Animal Welfare Act. And I do a lot of work under the Animal Welfare Act, and I do more work than the USDA does. But really, it's kind of not their fault. It's like, why did Congress give animal welfare to, the one agency that treats animals like a commodity? But that said, there are a few good people in there. But really, like the marine mammal stuff, like they've been regulating marine mammal captivity since that act was passed in 1966. It was 79 when they actually passed regulations for how captive marine mammals have to be treated, and those have not been updated since. Rumor has it they were a little bit, but not anything that mattered. But rumor has it they've got the next set of things that matter, but they're not going to be good. They said no, neither side will like them, and so they don't want to release them because we're both probably going to want to sue. So even when they give them to us, they won't get better. And then, and I don't know, so they just don't do their job. And they keep licensing zoos that violate the Animal Welfare Act, and the Animal Welfare Act is such a floor, and they won't even enforce that. So that's why.
And in the back?
So I have another sea lion related question. Given the delisting of the eastern continental U.S. population of yellow sea lions from the ESA, do you think it's likely that we'll see a petition to have those added to the brand and kill control measures at Bonneville and other locations?
Yeah, I mean, I don't even know that you would necessarily need a petition. I think, I'm not totally familiar with the terms, but it's more the number of animals. And so, and it's a 5-year permit, so maybe they'll just throw it into their next 5-year permit. But yeah, for sure they'll start killing them, and they were already killing them accidentally. I mean, some of these sea lions died because they got stuck in the traps and were left there for a couple of days, and are overheated, and it's just anyway. Yeah.
This is a question for Sue about the whaling countries. You described how few whales they take and how the countries often have to subsidize the markets. Can you talk about what the motivation for those countries to continue whaling is?
Oh, that's the question I always dread. There's multiple reasons. I think it's different for each of them. So Iceland, the Icelandic whaling industry, and it's the fin whaling industry, is one person. I mean, and it's been one person for 40 years. He's a leading businessman in Iceland. He controls a large proportion of Iceland's fishing industry. He comes from a whaling family. And it's his personal mission. It's his hobby, and it's his personal mission to keep Iceland's whaling industry alive. Even though there's no market for whale meat in Iceland, there is still in Japan. So he's found ways, and we're always chasing him, but he's always one step ahead. He's finding ways to get thousands of tons of fin whale meat into Japan. So he's tried to go through Europe, and we've shut down different ports to stop him taking that route. He went through Canada last year. We're trying to shut down the Canadian ports. It went from Halifax to Vancouver. It actually stopped in 2 US ports, and although it didn't enter the US, under US domestic law, even a ship transiting with marine mammal parts constitutes an import. So we're trying to go after him that way so it can't come back to the US again. And this year he got permission from Russia, because he's buddies with Putin, essentially. He got whale meat to go through the Northeast Passage, through the Arctic for the first time. Japan, I don't think Japan liked being told by the US at the end of the Second World War what they had to do. I think it goes back that far. I think Japan is concerned that how we regulate cetaceans will ultimately affect how we regulate fish. And tuna is massive, so valuable to Japan, a massive commodity. They're petrified that if you have bans on whaling, we'll end up with bans on tuna fishing. And the regulatory measures are so similar that they're very concerned about their precedent. And they don't like, and I understand this, being told by people who are, Westerners who don't understand, they think don't understand the cultural differences, what they should be doing. We kill, millions of cows and eat them and other animals. They think their whaling is sustainable. They think it's like fishing. They treat it like fishing. There's definitely a cultural disconnect. Does that answer the question? Yeah. I mean, there could be 50 other reasons, but I think also the harder we push Japan, the more they push back. I don't know what the answer is, but there is a significant cultural disconnect over whales between the West and Japan, and I don't know how we resolve that. Certainly, we can't enforce the ban to stop them.
I actually have a question for Sue. Why does Japan stay in the IWC, and why do Norway and Iceland, come and go? Or what's the motivation?
Because even though they love to describe it as dysfunctional, it gives them credibility. So if they left, and they've threatened to, they've postured each of the three of them for years, and Iceland went, but they had to come back for legitimacy. If they wanted to hunt whales, they had to do it within the IWC. If they didn't, the US has, I don't know if you're familiar with the Pelly Amendment to the Fisheries Protective Act in the US. The US has certified each of the three whaling countries several times for undermining the effectiveness of the ICRW by conducting whaling. But at least they're doing it within the ICRW through the loopholes that I described. If they left, I think the US would have to take serious measures against them. And there would be significant consequences on the international stage if they left and hunted illegally, if they really were pirate whalers.
Do you think that the actions of organizations such as Sea Shepherd are ultimately helping or hurting the issue? I know that they might be helping them in the short term, but do you think that they're hurting them in the long term by preventing those countries from coming to the table and reaching an agreement?
Oh, I always hate this question. I always get it. I don't think we're going, personally, this is me speaking personally, not for any organisation, Japan is not going to be forced out of whaling. So it's not going to be forced by legal means out of whaling. And it's not going to be forced by losing face, I think, out of whaling. And I absolutely support non-violent methods of protest. I don't know whether it's helped. I mean, it has certainly saved a number of whales. I don't know whether it's helped if your objective is to get Japan to say, okay, we're done. I don't know if it's helped. I think the ICJ case helped. I mean, certainly Japan, unfortunately, they've come back with a smaller a permit for fewer whales, which makes it even more economically unviable. The fewer you take, the less revenue there is from the proceeds under the scientific provision. Does that help? I don't know.
Yep.
So Sue, you mentioned a bunch of threats to the whale beyond commercial whaling. And hopefully we will see commercial whaling diminish in a way that those other threats would truly be, would represent a greater threat to the whales. But obviously we want to see those threats diminished as well. And you speculated about the possibility that the convention might be brought to bear on those other things. Is there language in the convention that could be applied to halt acidification or trash dumping in the oceans, and what execution of that treaty among the member states would allow them to bring the ICRW as sort of one more bit of ammunition to create political will against climate change.
Right, no, I think it's one more piece of ammunition. As I've described the creaky 70-year-old treaty with its slightly vague conservation mandate, there's nothing explicit that we can use to help. What it does have, though, every year is a gathering of the world's leading cetacean scientists. And because in the last 15 years or so, we've managed, the Commission has managed, and the NGOs have managed to turn the focus of the scientific committee away from counting whales to see how many you can sustainably catch, to start looking at these other threats. I think that's been very important and very helpful. The IWC certainly can't mitigate those threats alone, but what it can do is start to work with other conventions that might, and by having the scientific committee focus and produce very credible studies on some of these issues, I think we're getting the ammunition that we can start to use to address them. And then it's been doing these practical things like the disentanglement program as well. Maybe I oversold